Anna Edie for Ms. Torrance.
We have reset this thing at least 4 different times, I would imagine, because of this bond violation. One, I guess, evidentiary reason for CD to get evidence. Last time we were here, we were going to have a hearing. Unfortunately, we didn't have our pretrial services officer here. She's here now, so that's why we're having this hearing now to determine whether there is a true bond violation. Ms. Torrance is on bond for DWI that was initially filed August 28th, 2024. It's a second offense. So she was ordered to obtain a guardian interlock, or if she was not going to drive, obtain a portable device, and to blow in this portable device as according to the blow schedule. Our first bond violation report was filed October 8th of 2024. And I'm correct in saying that no action was taken on that bond violation.
She was admonished.
I admonished her. We did not do anything at that time. We now have another bond violation report that was filed January 24th, 2025. And in this violation,
break down a bond hearing that carries real weight. Right from the start, the prosecutor sets the stage with a DWI second offense, reminding the court that this isn't a first slip-up, but a repeat situation. The bond required either an ignition interlock or a portable device, and failure to comply would raise red flags. Then comes the big reveal: 13 skip tests, spanning random days, and no solid explanation yet on the table. The way it's delivered is calm but firm, signaling this isn't minor at all. It feels like the ground is already tilting against the defendant.
Report we have 13 skip tests on random days. And then I think that there were other issues as well, but I guess for me, the main concern would be she's not testing when she's supposed to. The floor is yours, Edie, if there's anything that you wanted to say.
Okay, well, let's see. The only thing I see alleged in the bond violation report is just skip tests. So I just want to make sure we're all on the same page. I don't know that there's any other allegations.
Okay.
That's correct. Okay. This is not my hearing, Judge, so I don't, if the state wants to call somebody or, you know, they have the burden, so whatever they want to do, I'm happy to respond, but they're...
Your Honor?
Tell me what happened with the missed test, if you don't mind.
Yes, Your Honor. We can call Pretrial Services Miss Felicia Chiles if she is available for one moment.
Do you mind coming up? Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but so help you God? Okay. State.
When the judicial notice of the court file, which is about the information.
Okay. Any objection?
I'm okay with the information. I would object to taking judicial notice of the report.
Okay.
So I'm not sure what all is included in the file.
We were addressing about the defendant here being charged. That's why we're asking for judicial notice of the court file regarding that element that we need to prove today.
Sure.
So,
Well, Mr. Chiles, is apologies. So you put it on bond for you're along the bond.
issues.
Yes.
You feel it, bond just
Evidence, and the tone changes immediately. Pretrial services is called up, sworn in, and we see the courtroom turn more formal and serious. The prosecutor wastes no time pressing for judicial notice and record admission, moving carefully through procedure. Defense objects lightly, but the judge admits the evidence anyway. It's a strategic moment. A paper trail just became courtroom fact. Suddenly, it's not about hearsay but officially logged violations. The tension rises because each admitted piece now anchors the narrative against the defendant.
Yes.
down the approach. This is still not an investigation of operation.
Yes.
Yes.
What's it?
There's a magistrate's conditions for the defendant.
What's wrong?
Okay, please. An objection?
No objection.
Okay, they'll be admitted. States 1, I guess.
Yes, sir.
Okay.
Yes. Please describe it on paper.
You're the real. Like always? Yes, we don't have to. So we have the defendant shall regularly appear in court on time every time in court. This case is set on the court's docket unless judge waives the appearance. The defendant shall commit no crime or shall not engage in any conduct that could result in his or her arrest. We have here the judge to obtain an ignition interlock device within 7 calendar days. Is this the most recent condition? She have a correct device. Fine. These are the most recent conditions. These are the IP. Can I have a little bit to represent?
Yeah.
Did you want to know this recent bond conditions? These are the first ones for the magistrate. Right now I'm printing out the amended bond conditions that we created on September 4th, the ones we're referring to with the portable device. So, the first two conditions are the same as I stated. However, instead of the ignition interlock, we have the plan to obtain a portable device within 7 calendar days, and that would be from the date of August 28th. And then no driving without permission of the court. We have no drug or alcohol usage. And then that same day, the defendant also was required to submit to a POC test. Return to work.
Young Wheel, please.
Sure, of course. So two, I guess states two would be the amended conditions of bond.
We're calling this case 3 if I'm fair on.
Okay. Sure.
No objection to this.
Okay, it'll be admitted.
Now we will be addressing the bond violation report.
Goodness. Wait.
Sure.
Who's that?
Yes.
That's all.
The bond violation report?
Yeah.
Yes.
Alright. Violations.
Objection, she's reading from something that hasn't been it yet.
Say car. Student, please.
Oh,
Here's where the heart of the matter lands. The bond violation report is laid out word for word. From December 9th to January 14th, the defendant had a test with a portable alcohol device and avoid alcohol use entirely. Yet across those weeks, she racked up 13 missed tests. The courtroom hears the specific dates, and the numbers paint a clear pattern of noncompliance. Pre-trial makes it clear, without regular samples, they can't supervise effectively. This isn't just paperwork. It's evidence that the bond conditions are slipping. The suspense builds because now it feels less like error and more like choice.
Number 2, Your Honor.
Okay,
no objection.
all right, it'll be admitted.
Details of violations.
Yes. The details read that the defendant was instructed to obtain a portable alcohol testing device and refrain from alcohol consumption. From December 9th to January 14th, the defendant has generated 13 skip tests. Pretrial is unable to properly supervise the defendant if the defendant is failing to provide samples during the scheduled time frames. Wasn't it a condition of bond to complete those portable tests? And how many again were not completed? What were those? 13. What were the dates? Between the dates of December 9th and January 14th. Thank you.
Any other questions for the witness?
No, Your Honor.
Okay.
Do they prepare a report of the missed blows with the specific days?
Yes, and that was provided to everyone here's email last week or the week before we had discussed.
Okay. Ms. Giles, what is your job title? Is that job title?
Judicial liaison.
And what do you do as part of your regular duty?
This is where the defense pushes back hard, and the strategy becomes clear. The attorney zeroes in on the machine itself. How does it work? Who checks it? And can this witness verify accuracy? One by one, the witness admits she doesn't know the technical details. Not the hardware, not the software, not how they interact. Instead, she says vendors and case managers handle verification. not her personally. That admission plants the possibility that the skip tests may not be fully reliable. It's a clever move, raising doubt about whether the system itself might be flawed, not just a defendant.
Judge and instruct clients over things that I can instruct over, so conditions that don't require devices in court. And if not, I send them over to our control services building for further instruction.
Okay. Do you know how the portable device works?
I'm very partially familiar, but not really, no.
Okay. Do you know how the software in the device works?
No.
And do you have any idea how those work together?
No.
So when you get a report, you have no way of verifying whether that information is accurate.
The vendor sends us the full report to our case managers.
And was the full report provided in the email that you referenced earlier?
Yes.
Okay. But there's no way to know that that device is working properly from your personal knowledge.
For me to validate if it's working correctly, me personally, no, but our case managers do.
Okay. I don't have any further questions for this, Judge.
Anything further?
Yeah.
Can the witness step down?
Yeah.
Thank you so much. All right. This argument. Do you have any more witnesses?
Yeah.
Do you have any witnesses?
Yeah.
Okay. Argument.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in County Court at Law number 5. And we just discussed the bond conditions that were pretty standard. And the violations here are very clear that there were 13 missed portable tests. And our pretrial services was able to confirm that. And we would ask that you would revoke the bond in this case.
Judge, this is the rules of evidence apply at this hearing.
Comes to a head with arguments and the judge's decision. The prosecutor insists the violations are undeniable and asks to revoke bond. The defense fires back, demanding a reset until someone with technical expertise can testify that the device was working properly. The judge listens, but her patience is thin, pointing out this isn't the first violation and she can't enable repeat behavior. She stresses that continued non-compliance undermines the court's authority. Then comes a dramatic close. Bond revoked, defendant taken into custody. And that's the moment everything collapses for her. Please hit like, subscribe to the channel, and don't forget to share. We'll see you in the next video. Thanks for watching.
This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs with regard to this. There's not anything else.
Okay, well,
I would say that the defense also has the ability to subpoena as well.
and this was set on Thursday, and it's also not my hearing, it's not my burden. I think without someone to testify that the machine was working properly, it's inappropriate to revoke her bond, restrain her liberty, the pecuniary punishment that goes with the bond revocation and paying a new bond, without knowing that the machine was working properly.
That's on them. If there's a problem with the machine, then it's on them to go have service or whatnot. So
Does she know it's
all I know, it's, well, then you're supposed to go there. You're supposed to go get it checked out. We can't micromanage every single thing. Number one. Number two, this is not the first time we've had this bond violation. We've had it before, and it continues to happen. I can't just let it go, man. I mean, I have to show you that we mean business. If I let you go now, then I'm enabling this behavior, and I'm in effect telling you it's okay when it's not okay. Skipping tests, second offense, it's done. All right, I'm revoking her bond. She goes with me. Doesn't make me happy to do it.